Ready? I'm calling to order this meeting. This is an additional meeting of the Committee of the Whole of the Council of the District of Columbia. I'm Phil Mendelson, Chair of the Council and Chair of the Committee of the Whole. Today is Tuesday, January 9th, 2024, and the time is 12:04 in the afternoon. And this meeting is being held almost entirely in room 500 of the John A. Wilson Building, the council chambers. I say almost entirely because I believe there's a council member participating virtually. Councilmember Gray, I see is on the screen. Good afternoon, Mr. Gray. We have three items. Well, actually, we have two items for markup in the Committee of the Whole, and then we have, I believe it's 4 items that have come through other committees. And considering the schedule for performance oversight hearings, then we will move to the legislative meeting. We begin our Committee of the Whole meetings with determining whether we have a quorum. Mr. Cash, would you call the roll?
Chairman Mendelson.
Present.
Councilmember Allen.
Here.
Councilmember Bonds.
Here.
Councilmember Fruman.
Present.
Councilmember Gray.
Here.
Councilmember Henderson.
Here.
Councilmember Lewis George.
Here.
Councilmember McDuffie.
Here.
Councilmember Nadeau.
Here.
Councilmember Parker.
Here.
Councilmember Pinto.
Present.
Councilmember Robert White.
Present.
Councilmember Trahan White.
Present.
Mr. Chairman, you have a quorum.
Thank you, Mr. Cash. As I indicated to members at the breakfast, I'm going to not move the Sentencing Commission nomination today. So the first item for markup is PR 25-542, the Ombudsman for Children, Patrina Jones Jazz Appointment Resolution of 2024. This resolution this is an appointment by the council. And the purpose of the resolution is to appoint Patrina Jones Jazz as the Ombudsperson for Children to serve for a term to end 5 years after the effective date of this resolution. The office of the Ombudsperson for Children was created by the council by Act in 2020. The Ombudsperson's mandate, and that is her title, Ombudsperson, mandate is to function as an independent office responsible to the council and tasked with improving outcomes for children known to the Child and Family Services Agency by holding relevant agencies accountable for fulfilling their responsibilities under the law. The Ombudsperson for Children is appointed by the council. And the Miss Jones Jazz currently serves as the acting Ombudsperson for Children. I believe she's been serving for about a year. And so we've had an opportunity to see how that new office has been achieving or been successful over the past many months. Since assuming the role of acting Ombudsperson, Ms. Jones Jazz has continued the work of establishing and solidifying a new agency. She's initiated improvement efforts, including the enhancement of the office's database and creating a sophisticated system for tracking constituent complaints and other information. Under her leadership, administrative procedures for entering complaints received in person, by phone, and email into the database were created and went into effect. Ms. Jones Jazz has also hired 2 additional employees. Their roles support the work and mission of the office by providing frontline service and communication to constituents and conducting investigations under the direction of the Deputy CFSA, Child and Family Services Agency Ombudsperson, and the acting Ombudsperson. She brings extensive experience as well as a demonstrated commitment to child welfare. The committee, I introduced this resolution on November 30th. And the Committee of the Whole held a roundtable on December 20th. The committee received no testimony or comments in opposition from anyone with regard to this nominee. Without objection, I'll move both the print and report with leave for staff to make technical, conforming, and editorial changes. Is there discussion? Councilmember Lewis George, and I should note before you say anything that CFSA comes under the committee that you chair, because this is a council appointment, that's why I'm moving the appointment. So please proceed.
Thank you, Chairman. I truly appreciate working in partnership with you and your staff to ensure that the Office of the Ombudsperson for Children is not only up and running as the independent office that the council unanimously voted to establish, but that the office has competent, caring, and knowledgeable leader who can hold agencies accountable for and improve outcomes for the district's children and family. I believe that Patrina Jones-Jez is that person. I first met Patrina after I became chair of Facilities and Family Services Committee, and Patrina was originally hired as the chief deputy ombudsperson. Since March, Patrina has been acting ombudsperson, and she has excelled in an office that the council and many advocates fought to establish. Despite a number of institutional challenges, she set up an office space, hired additional analysts, and put systems in place to ensure that children and families involved with CFSA are heard and that complaints are properly investigated. At a time when many of our children and families are looking for help or looking into understanding child welfare policies, it is vital to have a leader that understands what is at stake. There were 537 children in the care of CFSA last year. There are various reasons why children and families become involved with CFSA. As of 2021, 22 states had independent offices dedicated to children in foster care. I can't help but wonder how the situation may have been different with an independent office like the Office of the Ombudsperson for Children. It is important to have some empathetic yet knowledgeable about child welfare policies, and Patrina's years of experience in the child welfare system and her personal experience as a foster parent make me confident that she will be able to work with families, the community, and agencies to the benefit of children involved with previously involved with or otherwise known to CFSA. I look forward to continuing to work with Patrina to ensure children in care and families are heard, valued, and cared for. Thank you again, Chairman, for your work on this.
Thank you, Councilmember. Further discussion on this? The vote is on both the print and report with leave for staff. I think we can do a voice vote. Roll call. Let's do a voice vote. Let's try something new. All those in favor say aye. Aye.
Aye.
Aye.
Opposed? I don't see or hear any no votes. The ayes have it unanimously. Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Once the report and hearing record are filed.
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it
Does
does.
it have a fiscal impact?
No, it does not.
Yes, usually appointments do not.
Right. Her budget or her salary hasn't been budgeted.
Without objection, this measure will be placed on the consent agenda for today's legislative meeting. The next measure is Bill 25-350, MacArthur High School Designation Act of 2024. The purpose of this legislation is to officially designate the school on lot 899 and square 1356. That's off of MacArthur Boulevard at Q Street, to name it as MacArthur High School. This is an official naming. Looking at the report, the proposed designation's namesake is MacArthur Boulevard. The school is being named after the place where it is, on which the school is located. The District of Columbia Public Schools conducted a public online survey to solicit school name nominations for the district's newest public high school. It opened this past fall and has been operating unofficially under the name of MacArthur High School. More than 540 community members participated, and MacArthur High School received the most report. Many respondents indicated that the name should continue because it was what the previous school had been called for many years, and because the name was for its location rather than for an individual. That was the feedback that we got from the survey. The legislation was introduced at the end of June. I think there was a hope that it would be adopted before the start of the school year, except we had recess. The Committee of the Whole held a public hearing on November 28th, at which there were two witnesses, one who was opposed and the other representing DCPS. Other than that, I believe the committee has received no testimony or comments in opposition. Is that correct? I'm going to move both the print and report with leave for staff to make technical conforming and editorial changes. I do want to say a little bit more in light of discussion at the breakfast this morning. What I have found over and over again is that when we name a building, a street, a place after a person, that often these folks are not perfect people. This is actually named after the street, although some would say, well, but the street's named after a person. I think we have to be reflective of the naming process. And in this case, the DCPS community made clear for quite some time it was probably going to be named MacArthur School. And then there was this process that involved the public, followed by the hearing that we had that was very supportive of this name. The school's been operating under this name now for roughly 4 or 5 months. And I would just ask that members be reflective of what their view is on this and the effect on the process. So I move the print and report with leave for staff, as I said. Is there discussion?
All right, I just ask that this be placed on a non-consent agenda,
Okay,
and I will speak to it at the ledge meeting.
all right. If there's Councilmember Nadeau.
Yeah, I just have one question about school naming procedure. So we seem to not have hearings and voting on every school renaming. Is that right?
No, that's not correct. We have a hearing on every bill,
Yeah.
every street naming, or excuse me, every school naming is a bill.
Okay.
And I didn't make a list, but I was trying to remember this morning. We've, in the last couple of years, named Jackson Reed, John Lewis, Shirley Chisholm, Lorraine Whitlock. It's one of them I'm forgetting. Ida B. Wells. And every one of those had a hearing.
What's the history of council's role in naming schools?
In every one of those instances, except Jackson Reed, legislation was introduced until this. Chisholm, which we just acted on, I think final reading is today. Until Chisholm and MacArthur, the bills were introduced at the request of the mayor.
Okay.
The ones that have been introduced at the request of the mayor, as well as Chisholm and MacArthur, there was an extensive process with the community. Jackson Reed was a little bit of an exception, but on that one, I ended up having multiple hearings.
Okay. Thank you for that. Appreciate it.
There's no further discussion. By a voice vote with members who are voting no, asking to be recorded as voting no. All those in favor, print report with leave for staff, say aye. Opposed?
Chairman, please record me as no.
Councilmember McDuffie and Councilmember Lewis George
Please record me as no as well. Thank you.
and Councilmember Nadeau will be
Yeah.
recorded.
Peaceable is present.
Yes.
Mr. Chairman, please record me as no.
Councilmember Parker? I'm just making a note. So Councilmember Parker, that was you who just spoke? Very quietly down at that end of the dais? And Councilmember Parker, Councilmember McDuffie, Councilmember Lewis George, Councilmember Nadeau recorded as voting no. Councilmember Tran White recorded as present. The measure is approved. Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Once the report is filed,
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it
Does
does.
it have a fiscal impact?
It does not.
Okay, this measure will be placed on the non-consent agenda. I think it's listed on consent, but it will be taken off of consent. That concludes the items for markup in the committee of the whole. Measures from other committees. The first is Bill 25-425, Strengthening Traffic Enforcement Education and Responsibility Amendment Act of 2023. reported out of the Committee on Transportation and the Environment. Councilmember Allen.
Thank you very much, Mr. Chairman. Bill 25-425, the Strengthening Traffic Enforcement Education and Responsibility, or STEER Amendment Act of 2024, is a major reform to our traffic enforcement system that will empower the district to help get dangerous drivers off our roads. Before turning to what the bill does, I'd like to first reflect on the failures of our current traffic enforcement system. The district experienced 52 traffic fatalities in 2023. That's 17 more than the previous year and nearly twice as many deaths as we experienced in 2014, when the Vision Zero pledge to eliminate all traffic fatalities was first made by the mayor. This level of traffic violence is due in part to the sheer volume of speeding and dangerous driving that is happening in the district. For example, the Automated Traffic Enforcement, or ATE system alone, captured 1.2 million instances of speeding last year. One might think that behind each of those tickets, though, is a successful intervention. A driver sped, they received a ticket, they paid a fine for that violation, they modified their behavior to avoid another ticket in the future. And if one thinks that, unfortunately, they'd be wrong. In fact, data from the DMV shows there are over 27,000 people who owe more than $5,000 in unpaid citations. There's nearly 400 people that owe more than $25,000 in unpaid citations. There's one driver from Maryland that owes a mind-boggling $186,000 in unpaid fines. Important to note here that all told, less than 10% of all outstanding citations were issued to vehicles with District of Columbia tags. So how will the bill before us change things? Perhaps most significantly, the bill will allow the district's attorney general to sue drivers who have demonstrated histories of dangerous driving and can seek payment for outstanding tickets, the immobilization of their vehicle, the suspension of driving privileges. Importantly, this new system of accountability does not require a long desired but unfulfilled reciprocity agreement with Virginia or Maryland. Instead, a court order issued by the DC Superior Court can be enforced against drivers in all states and jurisdictions of the U.S. through the U.S. Constitution's full faith and credit clause. And once implemented, this will be one of the only enforcement tools that applies equally to both district residents and out-of-state residents. The bill also establishes a new immobilization framework to run in parallel with the DMV's current point system. Under the DMV's current point system, drivers who accumulate a certain number of points can have their licenses suspended or revoked. Under the immobilization framework created by the bill, DPW can, you guessed it, immobilize vehicles against which a certain number of points have been assessed. And because the immobilization framework looks only at the number and severity of traffic infractions over a 6-month window and does not consider where the associated fines were paid or unpaid, the immobilization framework is narrowly focused on dangerous driving behavior and does not impose additional consequences on someone due to an inability to pay their fines or ignore their dangerous driving simply because they are able to afford their fines. The bill also clarifies existing code provisions governing the suspension of driver's licenses and registrations based on certain criminal convictions, such as negligent homicide. Mr. Chairman, if I can have 30 more seconds.
Without objection.
Moreover, the bill establishes new requirements that individuals must meet to have their driving privileges reinstated after such a suspension. For example, the bill requires that a driver enroll in the newly established Intelligent Speed Assistance Program if their license was suspended based on a conviction involving excessive speeding. This new program will install speed governors in a person's car that limits the vehicle's speed based on the applicable speed limit. It's modeled after very successful ignition interlock programs. This new program allows a driver to maintain driving privileges while ensuring they can only operate their vehicle in a way that will no longer endanger other drivers, pedestrians, and residents. Additionally, the bill creates new reporting requirements between the DMV, OAG, and the Superior Court regarding DUI convictions and the resulting license suspensions. That is in response to data sharing issues that were uncovered through oversight by our committee and the council in the aftermath of the Rock Creek Park collision that killed 3 people last year. The bill also requires MPD to notify DDOT when a car has been stolen so that DDOT does not issue ATE citations to a stolen car until it's been recovered. For someone who has had a car stolen, it's frustrating to also receive a ticket in the mail and have to spend time and energy appealing speeding tickets that the thieves accumulated. And finally, the bill allows the DMV to waive fines for traffic infractions based on participation in and completion of safe driving courses. Specifically, the DMV can waive up to $100 in fines for each hour of participation, capped at $500 per year. The bill also requires that a person complete that class before having their vehicle released from mobilization for tickets that have already been paid. Together, I think this bill represents a package of reforms that will establish true accountability, regardless of ability to pay, for dangerous driving and make streets safer for all roadway users. I also want to specifically thank Councilmember Christina Henderson and Councilmember Brianne Nadeau for their partnership on working a lot of these ideas and the partnership with our committee. Thank you, Mr. Chairman. With that, I will move the bill. at the legislative meeting, I will be moving an amendment in the nature of a substitute, and I'm happy to speak to that then. And I'm stalling to try to give you a chance to finish your conversation.
You're doing an excellent
Thank
job,
you.
Councilmember Allen. Are there questions from members? Councilmember Nadeau.
Thank you. Councilmember Allen, would you agree that the point system in the committee print that prioritizes booting and towing towards the most dangerous offenses would result in fewer residents getting their vehicles impounded for failure to pay occasional parking tickets or one-off ATE violations?
That would be 100% correct.
Wonderful. I look forward to supporting this measure.
Thank you.
Mr. Chairman.
Councilmember Trayon White.
Thank you. I wanted to have a few on the record questions. Councilmember Allen, what constitutes one as a dangerous driver?
Do you mean for the mobilization framework?
Yes, because there's some provisions that will stop you from driving or getting a device put in your car if you're considered a dangerous driver.
Correct. So somebody who drives a car repeatedly at excessive speeds would be a dangerous driver. And under this framework, if you have citations of, let's say, up to 15 miles per hour, 5 times in a 6-month period. So you are repeatedly doing this 10 times within 1 year.
You said up to 15, up to?
11 to 15 miles per hour, correct. Also, if you're convicted of aggravated reckless driving, for example, a very serious conviction for dangerous driving.
Thank you. And I have an additional question. You talked about this device. What is the vision of this device if approved, and how would this work on cars, and how will the DC implement this device, putting on people's cars?
Sure. Just to make sure I'm clear, when you say device, do you mean the intelligence speed?
Immobilization. You said there was going to be some immobilization device.
There's the mobilization program. I think, do you mean the intelligent speed device?
Device. So it was my understanding there was going to be some type of device that was implemented during this bill.
Yes. So and correct me if I'm not answering what you're asking, but the legislation proposed creating essentially a pilot program to create a speed device. Think of it like a speed governor. It's something we have on vehicles that are in the district already. Other states have been piloting this. So for individuals that are convicted of these excessive and egregious speeding, you can install that on the vehicle. It would work in the same way that other speed governors work, in that you cannot speed. So it preserves someone's ability to have access to their vehicle and drive it, but it caps out essentially the speed with which they can achieve.
Thank you. And I know so is this voluntarily that we get this device? Will it be mandated by the district after you violate a certain amount of times? Who qualifies to get this device put on their vehicle?
I want to make sure I answer you correctly. So hang on 1 second while I grab that.
And while you're doing that, I just want to say this, Councilman Allen. I've seen a number of speeding tickets erected in the district over the last year. In fact, I think I read something in our budget last year that DC purchased over 300 new devices. And I'm noticing a lot of these speeding cameras are on a decline in certain areas, and 11 miles per hour is one of the measures of speeding. So it's trying to figure out, how this is going to be implemented as far as because the notion in your writing, you said that there was essentially no consequences for those who are speeding, and especially for those who have money. And I think that I don't personally believe that. I believe that DC has a number of consequences where you can get tickets, you can get booted, you can get towed, you can get your whole car taken. And that has happened even to the magnitude that DC impound lot is overcrowded, where they have nowhere else to put any cars because there's too many cars there. And a lot of people who have these cars towed are paying notes. So they have a car note and a car taken. So the notion that there are no tickets, there are no consequences. I don't know if that is accurate or not. I've heard a few members say they've heard that from the public. So if after you answered, if you can speak to that, that'd be helpful.
Sure. Well, I'll answer that part first and then get back to the speed assist. So we've got a driver who owes the district $186,000. We've got drivers that are racking up egregious, excessive, repeated speeding violations over and over and over again, and there are no consequences. And so that is a major factor of what's happening. I think I also look at the measure of how we determine the metrics of our own safe street safety in our community. How many parents out there are trying to walk their kids to school white knuckled,
Can I
holding their
comment
hands
on
to get
that?
across the street? Let me try to answer your question.
Okay.
So the way that we measure our safe streets is not just going to be 17 more people that died on our streets this year compared to last year. It's also going to be looking at how our neighbors and our residents feel trying to just walk around our neighborhood. I think people understand crossing the street feels a lot more dangerous and is more dangerous because of the excessive speeding we've seen. So to your question though, about the program or the device you were talking about, this is only for the ISA program, is for people whose license was suspended due to a criminal conviction. And this would be a new condition of that reinstatement. It works very similarly if you're familiar with the way in which after a DUI conviction, there might
Gotta
be an
blow
ignition
it.
interlock, right?
Mhm.
And the idea behind that is to, as part of that action, preserve the ability for people who are going to need to have a vehicle, but also have safety measures that are put in place. And so we're talking about, in this case, piloting this program where an individual who is convicted criminally of this excessive, aggravated, dangerous driving would then be able to still have their vehicle, which a lot of people probably wouldn't want them to have, but be able to use technology in a way that helps make sure we have that type of speed governor and assist there.
Thank you. And I heard the data that you reflected on of people with these outstanding tickets. Is it a fact that not even most, let's say over 70% of these individuals that you were talking about with these high numbers are Virginia and Maryland residents?
According to the data the DMV has provided us, DC tags make up about 10%. 90% is going to certainly a large share of that will be Virginia and Maryland. But when we look at the data the DMV has provided, a significant amount of that are other states as well from the area.
But this legislation speaks to DC residents as well, correct?
Well, from a legal perspective, we have to have a fair system that applies to everything. But the system we have currently, and I know you've talked about consequences. So especially for drivers who are not from the district, we don't have really any tools. We do not
Yeah,
have
that-
reciprocity, ticket reciprocity.
That's my point.
This will
So-
be a ability for us to now evenly and fairly, no matter where you live, be able to have a stronger accountability.
That's my point, because what I noticed is that we create this legislation like this with good intent, because we do want to make sure our roads are safe, but the bulk of that falls on DC residents who become unable to drive, and are unable to. So when we say there are no consequences, we leave out the part that they can't register their vehicles anymore. Correct?
I didn't hear the last part.
They
What?
can't register their vehicles anymore if they have these outstanding tickets.
Can a DC resident
Yeah,
register their vehicle in the district?
yeah.
We changed the law a couple of years ago that allows somebody, whether they're paid or unpaid, to be able to renew. Is that what you mean?
Renew their license. I'm talking about registered vehicle.
I think it's the same. But to the point of your consequences, it is, I agree with you. It is the district residents that bear the undue weight of the consequences of a completely failed system of accountability and safe driving. That's the system we got today, and this is going to change that.
So it's my understanding that if you have these outstanding tickets that you can't renew your vehicle. So that is a consequence because you just can't keep driving if you can't renew your vehicle. And that's going to fall on DC residents while Maryland and Virginia drivers get to continue with the same behavior. And in fact, it is known that a lot of people who are in DC that had this problem got Virginia tags and driving freely throughout the district, no insurance, hitting people's cars. The unintended consequences that we don't see is that people are choosing alternative measures to get tags, which is wrong. But those who don't have the money in turn creating all the other alternatives that may not be necessarily
The unintended consequences of a failed traffic enforcement system that we got today weighs heavy on the District of Columbia and our residents. Absolutely. I don't know if it'd be appropriate, Mr. McDuffie, I don't know if you could clarify on some of the clean hands language that we had passed to address Councilor White's question. But the system we've got today is failing us. It's making our streets less safe. And I think that this legislation is going to go a long way to fix that and create a fair system.
Thank you, Councilmember White. There was somebody over on my right side of the dais who also wanted to be recognized. Councilmember Henderson.
Yes, Mr. Chairman, I wanted to ask Councilmember Allen about the FIS for this bill. We don't often get revised FISs from the OCFO, so I was wondering if you could share a little bit about what caused the number to drop so precipitously, but also if you can speak to where applicability section or applicability language has been added such that the whole bill is not prevented from moving forward.
Thank you. So yes, we did receive a revised fiscal impact statement today, which reduced the overall cost by over $50 million. So that is significant. A large amount of that is specific to the reduction in the expectation of foregone traffic tickets and revenue. And so it's been revised down significantly, which I think is also, I appreciate continuing to work with the CFO and work with our agency partners to get to that. When we got the first fiscal impact, I think we just simply didn't believe it. We have had conversations with the budget office about ensuring that as the legislation moves to its final phase, that there is the applicability for each of that. And I'll note as well, there's only one component that can be absorbed thus far. That's MPD transmitting notice of stolen vehicles and tags. So that component depends on the other funded components. But we've had conversations with the budget office about ensuring the budget applicability.
Thank you.
Point of clarity.
Or just a question.
Councilmember Allen, because I read that this bill will cost $123 million in 4 years. Are you saying that that is broken up or in such a way where that would not happen all at once?
So the revised fiscal impact reduced that by $50 million. So it's significantly less than that. And then certain portions cost more than others. So obviously us allowing DC residents and others to waive fines, essentially not having to pay the financial cost, because at the end of the day, our goal actually should not be about revenue. It should be about changing behavior and safer streets. So if we're going to be able to say, you do not have to actually pay that cost. We want you to take that class. We want you to work in that costs us money. And so that's a large amount of what's reflected in the remaining FIS.
But it's only $100 per hour up to 5 hours. Is that accurate?
So we'd be giving everybody $500 a year off speeding tickets.
And Councilmember Pinto and I was discussing this. If you can tell us in practicality how that works, because if the DMV has to set up an operation for people to come in and take this class, it's open daily. And I know we set laws to have good intentions, but you know how I go. They don't have people set up, they don't have a space set up, and it's backlog. We gotta get on the calendar. And I'm a little leery about what happens in the wait time that you got these tickets accumulating every day, in which you got to pay at least $25 a day that your car is impounded or not picked up, even including Saturdays and Sundays when they're closed. How does it affect you getting these hours to get this $500?
Yeah, well, I agree with you. And I hope that people would keep that in mind and be worried about accumulating those costs, because the simplest way to avoid any of those costs would be to drive safely and drive the speed limit, because you never have to accumulate any amount of cost. But the idea is the agency, as we have worked with them, and I appreciate DMV and DPW and DDOT and all the agencies that have been a part of this. The idea would be that if you have accumulated that many dangerous driving tickets over and over and over again, if you then go into this space and your vehicle has been immobilized, that you're able to go and that the system would be set up that you go and you take that class to be able to work on being a better and safer driver.
Yeah, and can you send out the new FIS? Because I haven't seen that. I think it's
Sure, it was circulated this
73
morning.
million. What time?
It was circulated this morning.
Was it circulated by the CFO?
I believe it was circulated by the CFO this morning to everybody. 9:19 a.m. is what I'm told.
Councilmember Pinto for questions. Then Councilmember Freeman, did you want to be recognized after Councilmember Pinto?
Thank you, Mr. Chairman. Thank you so much, Councilmember Allen, for moving this bill today. A couple questions. Even with the $50 million reduction, once you account for the revenue that will be offset, Why is DMV suggesting that this point system will be so expensive?
Because you won't have to pay $500 worth of your speeding tickets if you take the class. And so because they build out a model that assumes that revenue would be coming in, to eliminate that revenue costs money. And so that's why that costs so much.
And how did you all come up with the $500 number as the right cutoff?
Looking at the amount of fines and trying to find a way that was responsive to what I think is a reasonable amount of fines that someone might collect, but also not create just an open-ended tally. Like there is no scenario where I think we should ever forgive $186,000 worth of speeding tickets. And I think you would agree. So trying to find a landing spot where a reasonable amount, but also if you're somebody that's got $20,000 worth of speeding tickets and violations, I cannot in good conscience ask the taxpayers to cover that. If we're looking for a more fair system though, that recognizes that we're going to see some bad behavior that we want to correct, then creating a cap, I think, is the right way to go.
Thank you. And then I just want to ask about speed limits, because this has come up a number of times today. Do you know how DDOT comes up with speed limits or some of the education that they are engaged with to educate drivers of what those limits are?
I am not an expert on every aspect of that, but I do know that the Department of Transportation is going to look to the Federal Department of Transportation standards that align on which roads are, in their language, which are arterial roads, minor, major, and they have designations for each road and street in our city. And then there are standards that are applied as to which are the applicable speed limits that go to each one of those. And so they don't have, for example, if any one of us felt like, hey, I'd love to change that speed limit on that block by 5 or 10 miles per hour, they don't have the ability to just do that on their own. They have to look to those standards and the policies that are set.
Well, thank you so much. I think that's a really important point I've heard a couple comments today and earlier this morning about the limit. And if you're only going 10 or 15 miles over the limit, but the speed limit is the limit.
That's the limit.
That you can drive. We can all drive less than the limit. And the limit is the highest maximum allowable that we can go. And in excess of that is violating the law. So lastly, do you think this is probably the single-handed most effective way that the council has acted in recent years that will improve the dangerous driving we're seeing on our streets?
It's a well-timed question. I think this is a absolutely major reform that is responsive to the failures of our system that we've seen. I think a collection of legislation this council has passed previously to focus on Vision Zero that unfortunately still isn't implemented is important. I think this will make an incredible, meaningful, and immediate impact on that. I also think, of course, designing our roadways and intersections to be safer is a major part of this. And so oftentimes people talk about the 3 E's, that you've got to have the type of enforcement that you need. You got to have the right type of education to drivers that you need. And you also have to have the right type of, maybe I didn't use my E's. You have to have the right type of engineering and design for our streets. Thanks.
Matt Truman, Councilmember Truman.
Thank you very much, Chairman Mendelson. Thank you, Councilmember Allen, for your work on this. On the FIS, as I recall, the FIS did not take into account any potential revenue that might be achieved through the OAG civil suits. Is that still the case? And if so, how much money is theoretically recoverable? We won't recover all of that, but how much money is theoretically recoverable?
Yes, you're 100% correct in that. And I say this with sincerity. I appreciate the hard work of the CFO to help do this, as well as their openness to look at, get more information and try to and provide a revision here. But the CFO frequently does not include revenue from something like this. So it does not include any revenue that would come in that the AG's office would collect. And so that would obviously bring the overall FIS down, but I think to be fair to the CFO, it is difficult to help predict exactly what that would be. If you were to ask me, how much would it be? I don't think we can know for certain, because it'll also depend on factors such as how many attorneys does the Attorney General have working in these cases? Which cases are they moving forward? So it's just really hard to predict, but it will undoubtedly create a mechanism by which we start to recover some of those funds, as well as, for the first time, create a accountability that applies not just to the district residents, but to Virginia and to Maryland and to everybody else.
No, I hear you. And I wasn't asking you to predict how much might be recovered, but I wonder how big that pot is. Theoretically, how much money could the AG be pursuing?
I think, again, if we think about what we are looking at in terms of just the experience we have thus far, when we have 27,000 people that have over $5,000 worth of unpaid speeding violations, when we have 400 people with more than $25,000, when we have the $186,000 example, that adds up to significant funds. I just could never be in a position right now to predict what that exact dollar amount would be.
Councilmember Bonds.
All right, well, thank you. To Councilmember Allen, just wondered a little bit about how this device that is placed on the vehicle operates. And what I am trying to understand, would it be operational exclusive to inside DC, let's say square radius or something? And what happens when you have to take your car on the highway? You're driving down to Florida, God forbid, but you're driving there and speed limit is 65. I'm just trying to understand what would happen with this device on your vehicle.
Sure. So we have devices already in the district where there's that type of device, like a speed governor that uses technology and geolocation to know where you are, where you can go, and how fast you can go. So it caps out and stops you at a certain speed. This is modeled somewhat after some pilots that have been working in New York. So in New York State, they've had a very successful model where they installed a similar device on, for example, their public fleet. And so the way it would work is that when you're on the interstate, let's say your speed limit there is 55 or 65 miles per hour, then your vehicle can go 55, 65 miles per hour. When you're on a neighborhood street where it's 25 miles per hour, then your vehicle can go 25 miles per hour. So it uses the technology. And so these devices already exist and are in practice in other places. So this will be the first time we're using it here, which is why I also think we want to let DMV help design what it would look like, defer a good amount to the agency to work in partnership with them to help create that. But that, I hope, answers the question around how that would be intended to work.
It really does. It just, made me wonder how this device would work and be monitored. So thank you very much for that.
Thanks.
Is there no further questions?
On the consent agenda.
No, it's not on the consent agenda. Actually, I have 3 questions. Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Yes, it is.
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does. And as discussed on the dais, it does have a fiscal impact. According to the revised fiscal impact, the cost is $11.5 million in FY24 and just over $77 million over the 4-year plan.
All right. There is an amendment nature of a substitute, if I remember correctly. So this will be on the non-consent agenda for today's legislative meeting. I'm sighing. I hope that the lengthy questioning is not a harbinger of how long we're going to spend at the legislative meeting. The next 3 measures were reported out of the Committee on Public Works and Operations, chaired by Councilmember Brianne Nadeau. The first is Bill 25-5, Uniform Commercial Code Amendment Act of 2023. Councilmember Nadeau.
Thank you, Chairman. Bill 25-5 was introduced on January 3rd by you, Chairman Mendelson, at the request of the Uniform Law Commission. The purpose of the bill is to make a number of amendments to the district's codification of the Uniform Commercial Code. Namely, the amendments add a new Article 12 named Controllable Electronic Records, which provides rules for transactions involving digital assets, including cryptocurrency, non-fungible tokens, and electronic promises to pay. The Uniform Commercial Code is a set of rules that facilitates commerce throughout the United States. It's been adopted in nearly identical form by every U.S. jurisdiction to ensure that the laws governing the transactions are substantially the same no matter where you are in the country. The UCC is updated periodically to keep pace with legal and technological developments. This latest set of amendments will ensure that the UCC continues to facilitate and adequately govern commercial activity by taking new and emerging technologies into account. The full set of amendments will classify non-governmental cryptocurrencies like Bitcoin and similar blockchain-based assets into a new category of personal property called controllable electronic records. Owners of these digital assets and lenders taking these digital assets as collateral will benefit from new rules designed to allow their greater integration into commercial markets without restricting their use to a particular purpose. The committee print made only technical changes to the bill, and the Committee on Public Works voted unanimously to approve the committee print and report on December 21st. Thank you. And with that, I request that this measure be placed on the consent agenda for the legislative meeting to follow.
Thank you, Councilmember Nadeau. Are there questions? Councilmember Henderson?
Thank you, Mr. Chairman. Thank you, Councilmember Nadeau, for presenting on this legislation. I know it's a uniform law. I was just curious, given that it's dealing with digital assets, whether or not the Department of Insurance, Securities and Banking was consulted on the measure, even though it wasn't referred to that committee.
Not that we're aware. And then the representative that we have on the Uniform Law Commission is OAG. So I think they probably do that work, but not that we're aware of.
Okay, thank you.
Yeah.
What did you mean by the representative we have on the ULC?
Sorry, we also have a representative, but the OAG rep.
Our general counsel, there's an attorney not
Yes.
from OAG, although that's where he
We have many
works.
qualified attorneys serving there that represent our government.
Correct. I think it's 5. Am I correct?
I'll just stop now.
Thank you. Did you have anything else, Councilmember Henderson? Any other questions from members? Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Yes, it is.
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Any fiscal impact?
There is no fiscal impact.
Without objection, this measure will be placed on the consent agenda for today's legislative meeting. Bill 25-282, Housing Subsidy Contract Stabilization Amendment Act of 2023. Councilmember Nadeau.
Thank you, Chairman. Bill 25-282 was introduced on May 1st, 2023 by myself, Councilmember Gray, and Councilmember Louis George. Because it deals directly with contracting and solicitation procedures, it was referred to the Committee on Public Works and Operations with comments from the Committee on Housing on May 16th, 2023. The committee held a hearing on this legislation on October 25th, 2023. There are 2 very similar acronyms I'll be using when discussing this bill. LRSP is the Local Rent Subsidy Program. Effectively, this is the district's local version of the Federal Housing Choice Voucher Program. The way that Housing Authority manages LRSP funding is with a long-term subsidy contract, or LTSC. LRSP is one of the most important subsidies we have for creating and supporting deeply affordable housing, including permanent supportive housing. LRSP was established and fully operational by 2007. As a result, many of the first 15-year contracts are coming up for renewal. Many affordable housing owners and operators reaching the end of their initial contract term can opt for the built-in 5-year extension without consequence. However, the same is not true for affordable housing projects looking to refinance and make improvements to a property or otherwise preserve deeply affordable housing. In almost every case, LRSP is not the sole financing source of a property. A project undergoing refinancing needs to line up on other resources, and it's extremely challenging, if not impossible, to secure the rest of this financing if a significant source of subsidy can only be guaranteed for an additional 5 years, well out of sync with the terms of those other sources. Because all LTSCs are by definition multi-year contracts, If the Housing Authority would like to renew subsidy for longer than a 5-year extension, current law would require that the contracts be competitively rebid. This puts projects in need of LRSP for refinancing, as well as DCHA, in a challenging and unintuitive position, with the possibility of a competitively bid contract being awarded to a different provider and thus different units of housing entirely. Put simply, the solicitation and contract procedures that apply to services or goods procured do not neatly apply to housing accommodations. Our current law could jeopardize the long-term housing security of extremely low-income tenants already living in LRSP units. The committee print makes a few changes compared to the bill as introduced, the most substantive of which is extending the maximum allowable term for an LTSC from 15 to 20 years, or whatever HUD currently allows for federal vouchers. LRSP was meant to closely mirror the Section 8 program rules, but since 2007, their contract terms have gotten out of sync. This will ensure that doesn't happen again. The remainder of the committee print changes are to ensure that the bill achieves its intent. While the bill as introduced amended only the Procurement Practices Reform Act, the print amends both the PPRA and the specific code sections governing LRSP to ensure continuity across the code. Thank you. And with that, I request this measure be placed on the consent agenda for the legislative meeting to follow.
Thank you. Are there questions from members? Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Yes, it is.
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does. No cost.
Without objection, this measure will be placed on the consent agenda for today's legislative meeting. Bill 25-412, Litter Control Amendment Act of 2023. Councilmember Nadeau.
Thank you, Chairman. Bill 25-412 was introduced on June 30th, 2023 by Chairman Mendelson at the request of the mayor, and the Committee on Public Works and Operations held a hearing on October 19th. The measure amends DC's official code to provide the Department of Public Works the ability to serve a party cited for infraction of the Litter Control Administration Act of 1985 with a notice of violation via first-class mail. It also provides that when such service is by first-class mail, 5 additional days must be added to the time period within which the party cited may or is required to take any action specified in the notice of violation. Finally, the bill codifies DPW's existing authority as determined by OAG to inspect and investigate a residential premises for an alleged nuisance, as there's currently no language in the code regarding DPW's authority to inspect an alleged nuisance at a residential premises. The committee print made several minor technical edits to the bill, as well as clarified that any DPW inspection or investigation of a residential premises may only occur from common areas at that premises. The committee received no comments or testimony in opposition to the bill and voted unanimously to approve the committee print and report on December 21st. With that, I request the measure be placed on the consent agenda for the legislative meeting to follow.
Councilmember Nadeau.
Chairman, with that, I request the measure be placed on the consent agenda for the legislative meeting to follow.
Thank you. Other questions from members? Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Yes, it is.
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does. And there is no fiscal impact to this measure.
Thank you. Without objection, this measure will be placed on the consent agenda for today's legislative meeting. The last item on our agenda is consideration of the schedule for public oversight hearings on fiscal year 2023-24 agency performance and expenditures. This schedule was circulated with the agenda. It has been compiled by the Budget Office working with the committees. As you know, there will be some changes made to this as we go through the 4, 5, 6 weeks of these hearings. And so this schedule will be published online, I believe, on the council budget director's website, also on the council's website, which is www.dccouncil.gov. And then as there are changes that also should be published where the schedule is otherwise published. Madam Budget Director, do you want to say something?
It's also published in the register.
And it will be published in the register. I'm told it'll be put on HMS by the committee soon. HMS is the hearing management system. If one goes to the council's website, you have, if you click on, I believe it's hearings, you get a choice of HMS, which is Hearing Management System, which is a new way of managing our hearings. Where all the testimony is going to be, the ability for the public to sign up. The print is awfully small, but it's all here. Any comments from members? This is not something we vote on, but this is something that is here. And if members have a comment right now, this is the opportunity, or we will move to adjourn. All right, there being no further business, we will the assistant secretary is so hard on me. We will start the legislative meeting at 1:10. The time is 1 o'clock and this meeting's adjourned. Madam Secretary, would you make sure the members are? We need workers' comp? We need workers' comp. Quorum call for the members. Quorum call for the members. 2, 3, 4. Quorum call for the members.
Yeah.
Do we need, Madam Secretary, do we need to get the marshals? Round up the members?
No, but I almost died.
Why? Mr. Assistant Secretary, are you rounding up members? One, 2, 3, 4, 5, 6. 6, 7. 7. Madam Secretary, are you ready? Madam Secretary, you ready? I'm feeling huge pressure. We got 7. You ready? Charles, are you okay if we start? I'm calling to order this meeting. This is a regular meeting of the Council of the District of Columbia. I'm Phil Mendelson, Chair of the Council. Today is Tuesday, January 9th, 2024. The time is 1:12 in the afternoon. This meeting is being held in person in room 500, of the council chambers of the Johnny Wilson Building, although I believe there's at least 3 members who are participating virtually. We always begin our meetings with a moment of reflection. I want to first recognize Councilmember Charles Allen.
Thank you, Mr. Chair. I think as a lot of folks know, this weekend, longtime council staffer and my committee director for the Transportation Environment Committee, Chris Laskowski, passed away unexpectedly. I want to thank my colleagues and council staff for your condolences, for your kind words. It is a heartbreaking loss for me and my team, I think for the council, for the city, and of course for his family. Chris was intelligent, kind, warm, witty, and just an inspiring part of my team, an inspiring part of our community. And I know with so many community partners that he worked with and partnered with, I appreciate your words and emails and notes that you've sent as well. And I appreciate you giving me a moment just in this time to just share that, and would ask that everybody, as you take your moment of silence and reflection, and the people and the causes that you're going to hold in that moment, that you please add Chris, but also his wife Ellison, his son Malcolm, and his wife and his daughter Marin, and hold them in that moment as well as I will. Thank you, Mr. Chairman.
Thank you. If we could have silence, please. Thank you. I do want to add this, we are a council of 13 different legislators, 13 different offices with central offices. The 13 of us like to, from time to time, disagree with each other, but in a sense, we're a family. And it's worth recognizing that. With that, Madam Secretary, would you please call the roll?
Councilmember Allen,
Here.
Councilmember Bonds,
Here.
Councilmember Freeman,
Here.
Councilmember Gray,
Here.
Councilmember Henderson, here, Councilmember Louis George.
Here.
Councilmember McDuffie.
Here.
Chairman Mendelson.
Present.
Councilmember Nadeau.
Here.
Councilmember Parker.
Here.
Councilmember Pinto.
Present.
Councilmember Robert White.
Present.
Councilmember Trahan White.
Present.
Mr. Chairman, you have a quorum.
Thank you, Madam Secretary. The first item of business is committee reports and the Secretary's report. I'll recognize the Chair Pro Tem, Mr. McDuffie.
Thank you, Mr. Chairman. I will move to waive the reading of the Secretary's report.
For the motion to waive the reading of the report, is there discussion? On the motion to waive the reading, all those in favor say aye. That was a little anemic. Are there any no votes? Don't hear any no votes. The motion carries. We also have the Secretary's report of introductions. Introductions and referrals. I'll again recognize the Chair Pro Tem, Mr. McDuffie.
And I will move to waive the reading of the Secretary's report of introductions and referrals.
It's been a motion to waive the reading. Is there discussion? On the motion, all those in favor say aye.
Aye.
Are there any opposed? I don't hear any opposed. The motion carries. We have the consent agenda. And I'm going to ask if there are any changes to the consent agenda. There are two that I know of on page 2, item C1 at the bottom. Bill 25-350 MacArthur High School Designation Act is taken off of consent. And on page 4, item E1, reading and vote on proposed resolutions, PR 25-507. That was not moved in the committee of the whole, so it's not on the agenda. Are there any other changes to the consent agenda? I'm not hearing from anyone any changes to the consent agenda. I'll repeat again, there are two measures that are removed. MacArthur High School, and not even on the agenda is Joel Castan today. If there are no other changes, we have the consent agenda before us. And I believe 3 members participating virtually. So Madam Secretary, if you would call the roll.
Councilmember Nadeau. Councilmember Parker.
Yes.
Councilmember Parker votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trahan White.
Yes.
Councilmember Trahan White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Fruman.
Yes.
Councilmember Fruman votes yes. Councilmember Gray.
Yes.
Councilmember Gray votes yes. Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Councilmember Louis George.
Yes.
Councilmember Louis George votes yes. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Mr. Chairman, there are 13 yeses.
The consent agenda is approved unanimously. Bill 25-350 MacArthur High School Designation Act of 2024. This was marked up in the committee of the whole. I spoke to it then. So moved. Discussion? We have the bill before us. We'll do a
Oh, sorry.
Councilmember Louis George.
I'd like to be recognized. Were we talking about MacArthur? Did you call for MacArthur?
Yes,
Okay, yes, I wanted to be recognized.
actually, I called you, but what's on the floor is MacArthur.
Okay, thank you.
Did you want to speak to it or?
Oh, yes, I did want to speak to it. I didn't know if that's where we were. Okay. Chairman, I wanted to speak, I'm voting against this bill because I can't support naming one of our outstanding high schools after an individual with a very troubling racist past. While I understand the desire for the continuity of name and the idea that the name is for the location and not the person, neither of those erase the name's indivisible connection with General Douglas MacArthur, a controversial military figure with a long history of racist behavior towards Black soldiers. Douglas MacArthur actively worked to obstruct President Truman's plans to integrate the United States Army. In addition, Thurgood Marshall went to Japan in 1951 in order to investigate irregularities in the courts martial of dozens of Black soldiers under MacArthur. I think it's important as we take this opportunity as a city, we've done an amazing job of righting the wrongs of those past, renaming some of our most beloved institutions. Many of us knew Wilson High School. For those who grew up here, it was an institution for years, and people said it's Wilson Tigers and we can't rename them. But we as a city boldly said, no, we are going to rename this school to Jackson Reed, and it has since excelled and lived up to the legacy of many of its alumni and alma mater. So continuity was a issue there, much deeper than the 1 year that this school has been operating, and which we stepped out and said this was something different. My grandfather served in the war. He is buried at Arlington Cemetery, Cannon Martin, and so many other Black soldiers who served this country and fought in wars. And we talk about our veterans and we talk about love for this country. I think a school should be named after someone who doesn't have this history or connection to mistreatment of Black soldiers. And so I think it would be more appropriate for the school to be named after a figure who is an inspiration or a role model for its community. It's not the first time some people said, let's not wait to the end of this. Dr. Fraser O'Leary, who's the vice president and Ward 4 state representative of the Board of Education, has been a part of this process and has voiced this, even including in the during the hearing that was had, and talked about let's doing this. This is what we'll be doing later today by changing the name of an elementary school from John Tyler to Shirley Chisholm. And this is what we should be doing with this high school. And we can and should do better than Douglas MacArthur for our students and for our Black veterans and soldiers. Thank you.
Thank you, Councilmember. Further on this, just a moment. Councilmember Fruman.
Thank you very much, Chairman Mendelson, and thank you, Councilmember Lewis George, for your comments. An effort was made here actually to very explicitly not say this is Douglas MacArthur High School, but name it after the place, not the person, and be clear about that in a certain way. That's sort of a dig at Douglas MacArthur. The continuity argument is it is different than in the Jackson Reed setting, in that this is a brand new school that doesn't yet have a community or a full community. When the process was done, I think Councilmember Henderson spoke to the fact that 500 people responded, and it's going to be a school of 800 students. So someday it's going to have a full community. Today, it actually does not yet. And also, we tried to do this to get this done, the naming, before the start of the school year, where money had to be spent in order to get uniforms, to paint the floor of the gym, to do different kinds of things. It's a building that's in the middle of a process. There's going to be a major addition added, and grades will be added in each year. We're trying to get this school to succeed and to have some familiarity and to attract students. And I think rejecting the name that was chosen by the community, such as it is at this point, hurts that school and undermines the effort to get it on its feet and successful. Now, could a day come where we have 800 students in the school, it's a full community, and we went back to the school and urged the school to reconsider the name? And if a choice was made that was different, DCPS funded the changes for the rebranding, which I understand that they would do. If any school community asks to be renamed, that's a process that can be done. We can do that sort of thing, but I don't think at this last minute, while we're in the middle of the school year, when money has been spent in order to get to where we are, that we should reject this name. We can revisit it at another time in the future. Nobody should think that there's anybody out there who's saying, let's use this name because we want to honor Douglas MacArthur. Quite the contrary. We're very clear it's not about Douglas MacArthur, but it is about helping a school get on its feet and redeeming the investment that's been made.
Further on the bill. I don't want to stimulate more debate, so I could keep quiet, but I do want to say this. Right now, the school officially does not have a name. It just doesn't. And if we were to vote no, then there's a question about whether its unofficial name would even be appropriate. I think it might make sense. I think it makes sense to go forward with this, but it might make sense to also say to the community, hey, you might want to rethink this. And so that they have something going forward, and at the same time, they could look at this in light of the issues that Councilmember Louis George has brought up. There's no further discussion. We'll have a roll call vote on this.
Thank you.
Mr. Chairman.
Councilmember Bonds.
Thank you. I was just wondering, based on your last comments, if this is an issue that we want to rethink, even at the dais level. And so should we postpone voting on this for some time?
I don't think so, because the part of what I was saying, and maybe not very well, is right now the school doesn't have an official name. And that really ought to be resolved. And my sense of student bodies in District of Columbia schools is they get sensitive in a right way about issues such as what Councilmember Louis George has brought up. And so I think that it's possible, I'm not going to say for certain it would happen, but possible that that school community would want to think about this some more. So they go forward with an official name because right now they don't have one, and they address this further. So I'm standing by the bill that was introduced and went through committee hearing that I chaired and that I moved earlier. Thank you. So we'll have a roll call vote on this. Madam Secretary?
Councilmember Parker?
No.
Councilmember Parker votes no. Councilmember Pinto?
Yes.
Councilmember Pinto votes yes. Councilmember Robert White?
Present.
Councilmember Robert White will be recorded as present. Councilmember Trayon White?
Present.
Councilmember Trayon White will be recorded as present. Councilmember Allen?
Yes.
Councilmember Allen votes yes. Councilmember Bonds?
Yes.
Councilmember Bonds votes yes. Councilmember Fruman?
Yes.
Councilmember Fruman votes yes. Councilmember Gray? Councilmember Gray? Councilmember Henderson?
Yes.
Councilmember Henderson votes yes. Councilmember Louis George?
No.
Councilmember Louis George votes no. Councilmember McDuffie?
No.
Councilmember McDuffie votes no. Chairman Mendelson?
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau?
No.
Councilmember Nadeau votes no. Councilmember Gray? Councilmember Gray will be recorded as absent. Mr. Chairman, there are 6 yeses, 4 nos, 2 presents, and 1 absent.
The bill is approved. We're on the non-consent agenda, but the next measure for consideration is on page 5. I feel as if we've already discussed this quite a bit already today. Bill 25-425, Strengthening Traffic Enforcement Education and Responsibility Amendment Act of 2023. Councilmember Allen.
Thank you, Mr. Chairman. I'm not going to repeat all the comments from the committee of the whole, but hope those can be incorporated. But I am going to move an amendment in the nature of a substitute. So shall I move that amendment and then
Yes.
speak to it? Okay, thank you. Following the Committee on Transportation and Environment's approval of Bill 25-425, my staff has been working very closely with the agencies and have received additional feedback from our implementing agencies. We've incorporated that feedback into this, and I am now moving, which makes some very small clarifying changes to the bill the committee had approved. Let me walk through those briefly. First, the ANS clarifies that the DMV has the authority to impose Excuse me. First, the ANS clarifies the DMV has the authority to impose additional requirements through rulemaking on drivers seeking to have their license reinstated. For example, the DMV wants to ensure that it retains the ability to require drivers who have had a DUI to maintain supplemental insurance, as the DMV does now. DMV could do this under the language of the committee print, but this amendment just makes sure that authority is very clear. The ANS also modifies provisions related to the creation of the Intelligent Speed Assistance Program, ISA. This would install ISA systems in the vehicles of drivers convicted of certain offenses while speeding 20 miles per hour or plus over the speed limit. The print gave the DMV the discretion about which type of ISA systems to use. To simplify administration of this program, the ANS specifies that the ISA program will install only systems, quote, that limit the speed at which a motor vehicle can travel based on the applicable speed limit. That is, cars with ISA installed will be limited to 20 miles per hour on residential streets, but could drive much faster on a highway, which I think was one of the concerns that have been expressed earlier. Furthermore, the ANS delays the requirement that the DMV submit a monthly report to DC Superior Court and OAG and a semi-annual report to the council regarding revocations initiated based on qualifying convictions by 1 year to January 1st, 2025. And the ANS also modifies provisions that prevent the issuance of ATE or parking tickets against a vehicle or license plate that was stolen. A committee print requires that MPD notify the DMV about any stolen vehicles or tags, so the DDOT would not issue ATE citations against the stolen vehicle or tag. The amendment broadens the mandate to require the MPD transmit this information to the DMV, DDOT, and DPW. Since DDOT is the agency that issues the notices of infraction for ATE violations, they should be included in that transmission. And since DPW may issue parking tickets against a stolen vehicle or tag, the amendment also requires that MPD transmit information to DPW and prohibits DPW from issuing parking tickets against stolen tickets or stolen vehicles or tags. Finally, the amendment requires that all law enforcement officers, not just MPD officers, notify the DMV of a suspected DUI. That is already the current practice. With that, Mr. Chairman, I move the amendment in the nature of a substitute.
Thank you, Mr. Allen. We have the amendment before us. Is there discussion on the amendment?
Chairman.
Yes, Councilmember White.
Yes,
And I'm going to watch the clock for folks.
please do. I acknowledge and support the intent of this bill and other measures that came into play in formalizing this bill from other members. What I am concerned is the lack of reciprocity we have over these other jurisdictions. And I'm afraid that we're going down this path to bring some type of accountability that don't exist with other jurisdictions, in which DC residents already have accountability measures put in place. And this would just double down and have a adverse impact on DC residents only. And Maryland and Virginia will go scot-free yet again as it goes to the courts, this has to go to Congress to pass. I'm just concerned about those unforeseen circumstances that I know that this impacts. And so that's one of the things I was trying to get questions on when it comes to how many were affected by this bill in percentage. And it was told that only 10% of those who had the high number of tickets were actually DC residents, and 90% were non-DC residents. And so just want to put that on public record for the record. Thank you, Chairman.
Thank you. Further, Councilmember Parker and then Henderson.
Thank you, Chairman. I would like to thank Councilmember Allen and his staff for advancing this important safety legislation. I was happy to support the legislation in committee, and I look forward to voting for it. I just want to add to the discussion that we've had today that in 2023, Ward 5 experienced more traffic fatalities than any other ward in the city. And since 2018, wards 5, 7, and 8 account for 2/3 of all fatal crashes in the city. And so while I appreciate the sensitivity the council has shown towards racial equity, it is important that we take action, because the people who are paying the price the most for our deadly roads are residents in wards 5, 7, and 8, many of them Black, brown, and low income. And I just would implore us to refuse to accept this pain and suffering as inevitable. Our roads are too big, our speed limits are too high, and our enforcement of our traffic laws fall short of what is needed to drive culture. So again, I want to underscore my belief that this legislation advances racial and economic justice and will not hinder it. Thank you.
Thank you, Councilmember Henderson.
Thank you, Mr. Chairman. 2 summers ago, followed following a spirited debate on the role of fines and fees and the district's clean hand laws in terms of traffic enforcement, I think there was an agreement amongst the council that it was time for us to look for alternative ways to meaningfully promote driver accountability and promote traffic safety. In the intervening time, we have invested millions of dollars with DDOT to and passed legislation to push for various infrastructure changes, whether it be raised sidewalks around schools, other different types of roadway designs, all in an effort and in the name of traffic safety and getting folks to slow down. I think this legislation is another component of that. Myself and other colleagues introduced bills, provisions of which were included in STEER out of a shared concern that the district's approach to traffic safety enforcement and accountability was not sufficient. The district will not meet the Vision Zero goals we set nearly a decade ago, and residents cannot be assured of their safety when walking to the pool, when biking or driving on or near the district's roads at this particular stage. Traffic safety is not just a policy issue, it is a shared responsibility that shapes the very essence of our community. This bill will move the needle on driver accountability through the Intelligent Speed Program, the changes to the Ignition Interlock Program, which we found through oversight hadn't been enforced or implemented, providing the Office of the Attorney General with civil enforcement authority, which gets to some of our neighbors in Virginia and Maryland. It structures our booting and towing system for prioritization through a new point system that penalizes unsafe driving behavior regardless of your ability to pay fines. And it also promotes increased agency collaboration. We desperately needed all of these changes, and I look forward to continuing this work to make sure that all of our roadways are safer for all users. So I want to thank the committee staff who worked diligently to move this bill. And I want to also thank Councilmember Allen for his collaboration and leadership on this issue. Thank you, Mr. Chairman.
Thank you, Councilmember Henderson. If there's no further discussion, we have the amendment nature of a substitute before us on a voice vote. All those in favor of the amendment say aye.
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 Are there any opposed?
Chairman, please mark me as present.
Councilmember Trayon White will be marked as present. The amendment is approved unanimously. The bill as amended is before us. Further discussion?
I can keep talking if you want me to.
No, you don't have to. The roll call, yeah. Roll call. Consulting with the Secretary, we'll do, because there's several members participating virtually, we will do a roll vote. Madam Secretary, please call the roll.
Councilmember Pinto,
Yes.
Councilmember Pinto votes yes. Councilmember Robert White. Councilmember Robert White votes yes. Councilmember Trayon White.
Present.
Councilmember Trayon White will be recorded as present. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Fruman.
Yes.
Councilmember Fruman votes yes. Councilmember Gray.
Yes.
Councilmember Gray votes yes. Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Councilmember Lewis George.
Yes.
Councilmember Lewis George votes yes. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Parker.
Yes.
Councilmember Parker votes yes. Mr. Chairman, there are 12 yeses and 1 present.
Thank you, Madam Secretary. The bill is approved unanimously. The next measures were on resolutions. The next measure is PR 25-603. As I indicated at the breakfast, I'm going to withdraw that, but before I withdraw it, I'm going to say this. As I indicated at the breakfast, but I'm going to make this clearer. At this point, the concern is the timing for the implementation of the budget enhancement, the SNAP benefits enhancement that the council approved. It's a matter of law that the mayor's indicated that she will implement. So what I'm going to look for is the 2 committees that have been involved with this, Committee on Health, chaired by Councilmember Henderson, who's been particularly active on this issue of the SNAP, getting the SNAP increase implemented, and the Committee on Housing, which has oversight over the Department of Human Services. I'm going to look to each of them to give me a sense before our February 6th meeting, whether it looks like things are proceeding apace. If they're not proceeding apace, then I will reintroduce the resolution to give council authorization. I want to emphasize this is authorization. It's not the decision to actually go into court. So stay tuned is what I would say. I'm going to look to the two committees. If we're comfortable that things are moving apace, then we don't need to bring it back.
Chairman, is it possible for us to do a date certain like we do with other
Who?
legislations?
No, because it's withdrawn. And that's
Okay.
what I'd indicated at the breakfast.
Okay.
But let me be clear, I don't mean to be so flip about this. In my mind, there's a date certain that I will bring this back February 6th. If it looks like things are moving apace on February 6th, but not a week or two later, I'll bring it back a week or two later. But I will add, just because now that I've said all this, I was in a meeting yesterday with Councilmember Henderson and Councilmember White, and the mayor was quite clear about proceeding with implementing this. So the next measure on the agenda is PR 25-566, Local Rent Supplement Program Contract Number 2024-LRSP-01A, Approval Resolution of 2023. Councilmember Robert White.
Thank you, Chairman. This is a resolution to approve a contract that will help a nonprofit called NHP Foundation refurbish 26 apartments and make them available to extremely low-income households in permanent supportive housing program. As members are aware, the Department of Housing and Community Development administers the Housing Production Trust Fund. DHCD coordinates with other district agencies that administer other housing subsidies, including the DC Housing Authority, which administers the Local Rent Supplement Program. Together, they run what's called a consolidated RFP process to make sure the different funding streams support each other. NHP was a successful bidder in the 2021 consolidated RFP. As a result, the council recently approved a $28 million HPTF contract with NHP. NHP is going to use those funds to perform major upgrades to 128 apartments. But those agencies running the consolidated RFP are also decided that this project should receive project-based housing vouchers. DCHA administers the local voucher program, so we need this additional contract. Unlike most contracts the executive sends to the council, which are eligible for passive approval, this one is a multi-year agreement that requires active approval under the Home Rule Act. DCHA and NHP intend to close their housing preservation deal later this month. DCHA filed the contract and the approval resolution timely for consideration today. If we don't adopt this resolution, the voucher contract will be disapproved on January 27th. Based on the materials we've received, this appears to be a worthwhile project. I therefore move the proposed resolution 25-566, the Local Rent Supplement Program Contract Number 2024-LRSP-01A Approval Resolution of 2023.
Thank you. We have the resolution before us. Discussion? Madam Secretary, would you call the roll? What? All right, if there's no objection, we'll do a voice vote. I've been trained, as long as several members are virtual, that we do roll calls, but apparently I'm being retrained today. So we'll do a voice vote unless somebody objects. All those in favor of PR 25-566, say aye.
Aye.
Are there any no votes? I don't see or hear any no votes. Madam Secretary, do you agree?
Agreed, Mr. Chairman.
All right, the resolution is approved unanimously. A final reading and vote on temporary legislation, Bill 25-594, Streetery Program Extension Temporary Amendment Act of 2023. Councilmember McDuffie.
Thank you, Mr. Chairman. I'm gonna like to move to postpone this measure for consideration till our February sixth legislative meeting.
It's been a motion to postpone to February 26th. If there's no objection.
February sixth.
Yes, I misspoke. Been a motion to postpone this until February 6th. There's no objection, the motion will be approved. Hearing no objection, it is approved. It's awfully quiet down there. Did you still want to say something?
Oh, we were having trouble hearing in terms of what bill we were moving to postpone. to February 6th.
Bill 25-594, Street Reprogram Extension Temporary Amendment Act of 2023.
Thank you.
And without objection, it was postponed to February 6th. So we'll turn to emergency legislation. The first measure being moved by me, the Historic Preservation Review Board Succession Emergency Declaration Resolution of 2023, PR 25-585. The purpose of the underlying legislation is to allow the Historic Preservation Review Board to maintain a quorum until one of its 5 current members, Marnie Keith, can be approved by the council. The legislation will extend the holdover length of HPRB members, which is this particular member, to 225 days rather than the current 180 days. The HPRB has 9 members, but right now there are 4 vacancies. And of the 5 filled seats, Marnie Keith is currently serving in a holdover capacity that will lapse on or around January 17th. Her nomination has been sent down. Her nomination for reappointment has been sent down last week, and the committee of the whole has scheduled a hearing, which actually will be a roundtable on January 10th, which I think is tomorrow. Unless there are problems, we will come forward with her reappointment confirmation, and this allows all that to happen without the board lapsing into inability to act because of the lack of a quorum. I move the declaration. Discussion,
Mr. Chairman,
Councilmember Henderson.
how many vacancies are currently on the Historic Preservation Review Board?
4.
Okay. Have you all received any nominations for those?
No.
Okay.
There are, I have been corresponding with MOTA since October. And I understand that there are, I want to say 4 nominations that are in process. And I expect to get them, I want to say shortly, but I don't know if shortly means this week, this month, or next month, but I'm pretty sure they'll come in.
Okay, thank you.
So there are 9 members, 4 vacancies, which leaves 5. Marnie Keith is in a holdover, so on or around January 17th, there will be 5 vacancies. With this emergency, there will continue to be 4. Further? Roll call. All right, we'll do a roll call on this one because it requires a 2/3 vote. Madam Secretary, would you call the roll? The vote is on the declaration.
Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trahan White.
Yes.
Councilmember Trahan White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Fruman.
Yes.
Councilmember Fruman votes yes. Councilmember Gray.
Yes.
Councilmember Gray votes yes. Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Councilmember Lewis George.
Yes.
Councilmember Lewis George votes yes. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Parker.
Yes.
Councilmember Parker votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Mr. Chairman, there are 13 yeses.
Thank you, Madam Secretary. The declaration is approved unanimously. I move the underlying bill, Bill 25-644. Discussion? Since the declaration was unanimous, we'll do a voice vote. All those in favor of the bill say aye. Aye.
Aye.
Aye.
Anemic. Are there any no votes? I don't hear any no votes. The bill is approved unanimously. PR 25-606, protecting consumers from unjust debt collection practices, technical clarification amendment, emergency declaration resolution of 2024. This is being moved by me. The council adopted legislation in 2022 that became, maybe we adopted in 2021, that became applicable as of January 1st last year. It concerns debt collection practices. Public utilities are subject to the requirements in that law. However, after we adopted it, there were a few concerns that were brought to our attention. Last year, the council approved emergency and temporary legislation to address those, what do I call them, variances with the public utilities. That legislation has or is about to, actually it expired 4 days ago. And so this is a new round of emergency and temporary. Looking at the notice to avoid confusion or negative impacts on customers or utilities, it's necessary to clarify that certain specific regulatory requirements for utilities are permitted under this debt collection practices law. Identical legislation was enacted last year, as I noted. This is a new round of emergency and temporary, and we will need to move on permanent legislation. I move the declaration. Is there discussion? Madam Secretary, would you call the roll? The vote will be on PR 25-606.
Councilmember Trahan White.
Yes.
Councilmember Trahan White votes yes. Councilmember Allen. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Fruman.
Yes.
Councilmember Fruman votes yes. Councilmember Gray.
Yes.
Councilmember Gray votes yes. Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Councilmember Lewis George. Yes. Councilmember Lewis George votes yes. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Parker.
Yes.
Councilmember Parker votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Mr. Chairman, there are 13 yeses.
Thank you, Madam Secretary. The declaration is approved unanimously. I move the underlying bill, Bill 25-662. Is there discussion? Since the declaration was unanimous, we'll do a voice vote, which I hope has a little more energy behind it. All those in favor of Bill 25-662, say aye.
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 Are there any opposed? I don't see or hear any no votes. The bill is approved unanimously. The next measure which I am moving is School Improvement Emergency Declaration Resolution of 2024, PR 25-590. The purpose of this emergency is to implement the permanent legislation more quickly, since it requires a report from the Office of the State Superintendent on Education to be completed by the end of this fiscal year. The permanent bill was approved on second reading, final reading earlier in this meeting. The purpose of the legislation overall is to elevate school support as an urgent priority for the district and to give authority to OSSI, the Office of State Superintendent, to work directly with the lowest performing schools. The fiscal impact on the permanent legislation is small, but nonetheless exists. It's about $150,000 a year, but not this fiscal year. And so the permanent legislation has a subject to a appropriation clause in it. In fact, I should have noted that, except we can't discuss legislation on the consent agenda, but general counsel is going to put that applicability provision in the permanent. Because of this, the emergency is a shortened version of the permanent and only includes the provision necessary for OSSI to do the report, the plan that they have to do this fiscal year. This measure as an emergency allows OSSI to move forward with immediately to meet the September 30th, 2024 deadline for report submission. I move the declaration. Is there discussion? There'll be a roll call on the declaration, PR 25-590, Madam Secretary.
Councilmember Allen,
Yes.
Councilmember Allen votes yes. Councilmember Bonds,
Yes.
Councilmember Bonds votes yes. Councilmember Freeman,
Yes.
Councilmember Freeman votes yes. Councilmember Gray,
Yes.
Councilmember Gray votes yes. Councilmember Henderson,
Yes.
Councilmember Henderson votes yes. Councilmember Lewis George.
Yes.
Councilmember Lewis George votes yes. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Parker.
Yes.
Councilmember Parker votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. And Councilmember Trayon White.
Yes.
Councilmember Trayon White votes yes. Mr. Chairman, there are 13 yeses.
Thank you, Madam Secretary. The declaration is approved unanimously. We have the underlying bill, Bill 25-650. So moved. Discussion? Since the declaration was approved unanimously, we'll do a voice vote on the bill. All those in favor say aye. Aye.
Aye.
Aye.
Madam Secretary, could you check and see if the oxygen level is high enough in this room? Opposed, are there any opposed? I don't hear any. The bill is approved unanimously. The next measure, which I'm also moving, is term clarification emergency declaration, resolution of 2024, PR 25-588. The purpose of this legislation is to immediately implement Bill 25-342, the Term Clarification Amendment Act of 2023, on an emergency basis. This legislation was originally introduced, or that legislation was originally introduced at the request of the Public Charter School Board to clarify that a member of its board could serve an additional full term if the mayor chooses to renominate him. And that's because his initial term was a partial term. I mentioned this at the breakfast, struggling with these partial terms on boards in which there is a term limit. The Committee of the Whole, in its markup of the bill, expanded the scope of the permanent legislation to effect other changes to laws regarding nominations and appointments. Importantly, the legislation makes changes to the Administrative Procedure Act and the District of Columbia Codification Act 1975 to clarify that publication in the District of Columbia Register is not a prerequisite to legislation becoming effective. It is desirable that this too becomes effective as soon as possible, since it reflects current practice. As we know, particularly with bills, because they all have this effective date clause at the end, legislation becomes effective after it's completed its congressional review, or in the case of emergencies, once the mayor has signed it, or has returned it unsigned, or has vetoed it and we overturn the veto. In any event, that's when legislation becomes effective, not when it is published. And so this bill, the permanent bill, clarifies all that. The emergency bill will make that happen more quickly. The permanent bill also addresses the situation of reappointments to the out-of-school time commission, which has a term limit. And when we adopted this bill on a final reading in December, I inadvertently had language that did not fix that correctly, which is why the permanent will show up later on this agenda as a reconsideration. In any event, the emergency legislation reflects all components of the underlying permanent bill, including the permanent bill as it will be amended shortly. I move the declaration. Is there discussion? We will have a roll call vote.
Councilmember Bonds,
Yes.
Councilmember Bonds votes yes. Councilmember Freeman.
Yes.
Councilmember Freeman votes yes. Councilmember Gray.
Yes.
Councilmember Gray votes yes. Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Councilmember Lewis George.
Yes.
Councilmember Lewis George votes yes. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Parker.
Yes.
Councilmember Parker votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trayon White.
Yes.
Councilmember Trayon White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Mr. Chairman, there are 13 yeses.
Thank you, Madam Secretary. The declaration is approved unanimously. We have the underlying bill, Bill 25-647. So moved. Is there discussion? Since the declaration was approved unanimously, we'll do a voice vote, hopefully with enough oxygen in the chamber. All those in favor say aye.
Aye.
Are there any opposed?
Wow.
Madam Secretary, did you hear the vote?
No, Mr. Chairman.
Well, we're not going to repeat it. The ayes have it unanimously. The next measure is PR 25-587, Shirley Chisholm Elementary School Redesignation Emergency Declaration Resolution of 2024, which I am moving. The purpose of the legislation is to officially redesignate, that is rename the school now known as Tyler Elementary School to rename it as Shirley Chisholm Elementary School. The permanent legislation implementing this official naming was approved just within the past hour or so on final reading. DCPS had requested that we do this on an emergency basis. That is, we get this effective immediately. I think because of the school lottery and they want to have the new name in the lottery instead of the current name. So I agreed to propose that we do this immediately, which is why the declaration is before us. I'm not going to say much about the names because we've already discussed names enough today, but so moved on the declaration. Is there discussion?
Mr. Chairman.
Mr. Allen.
Thank you. I know we have already debated and this council has successfully passed legislation changing the name. So I appreciate that. I just want to reiterate how important this name change is. My gratitude to the entire community around the school that went through a very long, thoughtful, deliberative process to make this change and how eager and excited they are to be Shirley Chisholm Elementary School. And I'm very excited to be able to make that name official as well. And I appreciate the action today that's going to allow that to happen and make sure the school is ready for the new school year in the fall with all the signage and with the name changes and all the things. And also a quick thanks to DCPS for being a really great partner in this name change and helping support that. Thank you, Mr. Chairman.
Thank you, Councilmember. Further discussion on the declaration? We'll have a roll call vote, Madam Secretary.
Councilmember Freeman.
Yes.
Councilmember Freeman votes yes. Councilmember Gray.
Yes.
Councilmember Gray votes yes. Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Councilmember Lewis George.
Yes.
Councilmember Lewis George votes yes. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Parker.
Yes.
Councilmember Parker votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trayon White.
Yes.
Councilmember Trayon White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. And Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Mr. Chairman, there are 13 yeses.
Thank you, Madam Secretary. The declaration is approved unanimously. We have the underlying bill, Bill 25-646. So moved. Is there discussion? Since the declaration was approved unanimously, we'll do a voice vote. All those in favor, Bill 25-646, say aye.
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 Are there any opposed? I don't see or hear any no votes. The ayes have it unanimously. The next measure is PR 25-589 Medical Cannabis Program Enforcement Emergency Declaration Resolution 2024. Councilmember Allen.
Thank you, Mr. Chairman. Back in 2022, the council started a debate about how to respond to the presence of unlicensed establishments across the district that sell, deliver, or exchange cannabis as part of a commercial transaction. These establishments, which are known across the district as I-71 or gifting shops, are part of a gray market in the district that's estimated to take in more than $600 million in sales annually. These establishments do not pay the taxes and fees that licensed facilities under the district's medical cannabis program must pay, and most are owned by non-district residents and sell products that are untraced, untested, and mostly cultivated outside of the district. The presence of some of these establishments have also raised serious public health and safety concerns. Some of these establishments are located in areas in which legal facilities are not allowed to operate, such as within 300 feet of schools or recreation centers. These businesses have also been the target of criminal activity, such as robbery and theft, and some have been implicated in criminal activities themselves, including illegal possession of firearms and illegal possession and distribution of narcotics. In December 2022, the council passed the Medical Cannabis Amendment Act of 2022 to provide an on-ramp for these establishments to come into compliance and obtain a license under the district's medical cannabis program. The open application period began on November 1st, 2023, and will close in just a few weeks on January 29th, 2024. With applications coming in, the Alcoholic Beverage and Cannabis Administration already accepting and placarding establishments, and ANCs across the district are weighing in. Several issues have come to the forefront regarding the current process, and I convened an implementation discussion with advisory neighborhood commissioners in Ward 6 just last month. First and foremost is enforcement. Right now, under current law, neither ABCA nor the Department of Licensing and Consumer Protection have the authority to issue warnings, fines, or cease and desist orders against unlicensed establishments that do not seek to apply to become a part of the district's medical cannabis program. That's a problem. This gap in the law, if not fixed, will render the on-ramp meaningless, allow unlicensed establishments that do not apply to keep on operating, and significantly harm the good actors that have applied. They're seeking to become a part of the medical cannabis program, working with their ANCs and community. It is important that the on-ramp serves its intended purpose, and for it to do so, enforcement against unlicensed establishments that do not pursue licensure is required. Additionally, as it relates to enforcement, concerns have been raised about the ability of the Department of Licensing and Consumer Protection to issue warnings and fines to commercial landlords of these unlicensed establishments. That's going to be an important tool, but currently unfunded and therefore not effective. Second, the implementation discussion that I had with our Ward 6 ANCs revealed that it's not clear who has standing to protest the issuance of a license to an unlicensed establishment that does apply. Right now, for example, any ANC in the ward where an applicant is located can protest. It kind of makes it a little confusing. So for example, if I have an applicant located in ANC 6A on the H Street corridor, then ANC 6D, which is located miles away in Southwest, could protest that license and enter into a settlement agreement with the applicant. Additionally, the current law excludes ANCs that might be in a different ward, but simply just across the street from the applicant, with the ward boundary separating them from being able to protest. Sticking with my Ward 6A example, if there's an applicant across the boundary in Ward 7 on 15th Street, then ANC 6A wouldn't have standing to protest despite the fact that it's just across the street.
Without objection.
30 more seconds. Resolving these issues today is important. As the open application period closes in just under 3 weeks, enforcement is a crucial piece to ensuring the success of the licensing on-ramp that we've created for unlicensed establishments to come into compliance. Furthermore, we all know it's important for our ANCs to be able to effectively use their voice and work with the establishments to proactively address issues and make our neighborhoods thriving and welcoming places to live and do business. Lastly, Mr. Chairman, I want to thank you and your staff, as well as my colleague, Councilor McDuffie and his staff, for working with me and my staff on this emergency legislation. I also want to thank Director Musali and his staff over at ABCA, as well as the staff at Department of Licensing and Consumer Protection for their feedback and partnership in working on this legislation. Thank you, Mr. Chairman. And with that, I'll move the declaration.
Thank you, Councilmember Allen. Is there a discussion? We have the declaration before us.
Mr. Chairman?
Somebody said, Councilmember Pinto.
Thank you very much, Mr. Chairman, and thank you, Councilmember Allen and your entire team for introducing and moving this emergency today. It is very important for us to have a strong medical cannabis market to meet our residents' needs and ensure that cannabis products are safe, accessible, and well regulated. And I'm enthusiastic that we are on this path. The proliferation, though, of unlawful cannabis businesses undermines our ability to meet these goals, which is why the council created a pathway for currently unlicensed businesses to become licensed in the medical cannabis space. This regulatory scheme allows, among other things, for medical cannabis products sold in the district to be tested for safety and effectiveness and ensures that cannabis businesses do not locate in inappropriate areas like next to schools or recreation centers. We have made the pathway to licensing as accessible as possible for businesses that are currently operating, balancing consumer protection with economic fairness, and many businesses are in the process of obtaining licenses now. It is also essential that the district is able to provide effective oversight of licensed establishments and enforce regulations against unlicensed and non-compliant businesses. This emergency legislation today will further strengthen our enforcement regime by ensuring that ABCA, as well as MPD and the Attorney General, have the tools needed to ensure that cannabis businesses comply with our laws and are held accountable if they do not. Additionally, I appreciate the provisions ensuring that local ANCs within 600 feet of an establishment applying for a medical cannabis license will now have the ability to protest during the licensing process. However, I do want to make clear that as we move forward, I remain concerned about a larger category of people who may have a vested interest in a particular license. For example, parents of children who attend a nearby school but might not live in that ANC and should have standing to protest that license. I also think we should consider the importance of consistency in rulemaking and regulation for alcohol and medical cannabis. We have an existing regulatory scheme right now for alcohol that includes rights for various interested parties, in addition to ANCs, to have standing during ABCA's consideration of a license, including abutting property owners, informal groups of district residents, and established community associations. Why not for cannabis? As we continue to evaluate and consider our larger medical cannabis regulatory scheme in permanent legislation, which is coming, we should aim to create more consistency in this regard and ensure that our medical cannabis regulations are at least as stringent as our alcohol regulations. So thank you very much again, Councilmember Allen, to you and your team, and for your work in collaboration with ABCA and Councilmember McDuffie and Chairman Mendelson for bringing this emergency forward today. And I look forward to working with the Committee on Business and Economic Development to continue considering additional safeguards around cannabis regulation as we move forward. Thank you.
Thank you, Councilmember Pinto.
Mr. Chairman.
Councilmember McDuffie?
Thank you, Chairman, and thank you, Councilmember Allen, for all the work that you and your team have done and for working with me and my team on this emergency measure. When the council passed Medical Cannabis Amendment Act of 2022, we provided unlicensed establishments with a real pathway to enter the market without having to face the immediate threat of enforcement. This pathway opened on November 1st of last year, and to date, 37 establishments have taken advantage of this opportunity and applied for a license during the open application period. This measure before us today ensures that we retain this legitimate pathway while clarifying enforcement procedures for unlicensed establishments that choose not to apply during this open application period that ends on January 29th and continue to operate in violation of the law. So I plan to support this measure today. And again, I want to thank Councilmember Allen and his team for their collaboration on it.
Thank you, Councilmember. Further discussion? We have the declaration before us. PR 25-589. Madam Secretary, would you call the roll?
Councilmember Gray,
Yes.
Councilmember Gray votes yes. Councilmember Henderson,
Yes.
Councilmember Henderson votes yes. Councilmember Lewis George,
Yes.
Councilmember Lewis George votes yes. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Parker.
Yes.
Councilmember Parker votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trayon White.
Yes.
Councilmember Trayon White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. And Councilmember Fruman.
Yes.
Councilmember Fruman votes yes. Mr. Chairman, there are 13 yeses.
Thank you, Madam Secretary. The declaration is approved unanimously. We have the underlying bill, Bill 25-648. Councilmember Allen?
So move, Mr. Chair.
This discussion. Since the declaration was approved unanimously, we'll do a voice vote. All those in favor of the bill, Bill 25-648, say aye. Aye.
Aye.
Are there any no votes? I don't see or hear any no votes. The bill is approved unanimously. We have three measures that were introduced at the request of the mayor. The first is being moved by me. The declaration is protecting adjacent and adjoining property owners from construction damage emergency declaration resolution of 2023 PR 25-601. So moved is, I should say something about it. Yes, I should. And guess what? I put the piece of paper somewhere. On December 20th of 2022, the council approved permanent legislation. The law requires property owners, contractors, or persons applying for specific types of permits. I'll emphasize for specific types of permits to obtain liability insurance that covers loss or damage to adjacent and adjoining property owners for certain permits issued by the department. And I'll emphasize for certain permits. Following the enactment of the law, the Department of Buildings determined that 3 additional permit types should be included under the law due to the potential risk of damage or injury to a neighboring property. These additional permits are alteration and repair permits, where the applicant will be engaged in underpinning or specific other construction activity, a foundation permit, and a new building permit. The failure to have included these permit types under the law leads to a significant gap in the protection afforded to adjacent and adjoining property owners. The executive brought this to our attention and asked that we amend the law on an emergency basis to include these additional permit types. We have the declaration before us. I'm going to have an oral amendment to the bill. And I am just looking at this for the first time. I have an oral amendment, and the oral amendment's going to add underpinning. I don't know if that's a specific permit. I don't think it is, but I just want to make sure that, I guess what I'm saying here is because the oral amendment will be to the bill, that if necessary, the declaration be amended to reflect that it would include underpinning. Don't ask me where, because I don't have it in front of me. I'm just saying that the bill is going to have underpinning in it, and the declaration should reflect that. So I move the declaration, and I hope I haven't confused folks. Is there discussion? I will have a roll call vote on the declaration PR 25-601.
Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Councilmember Lewis George.
Yes.
Councilmember Lewis George votes yes. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Parker. Councilmember Parker votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trayon White.
Yes.
Councilmember Trayon White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Fruman.
Yes.
Councilmember Fruman votes yes. And Councilmember Gray.
Yes.
Councilmember Gray votes yes. Mr. Chairman, there are 13 yeses.
Thank you, Madam Secretary. The declaration is approved unanimously. The underlying bill is Bill 25-652, so moved. And as I noted, I have an oral amendment, which is on line 33, I believe, to add the word underpinning. The provision, which looks like it's a subparagraph I, would read an addition, alteration, and repair permit pursuant to which the applicant will be engaging in underpinning, construction at the property line or on the party wall of an adjacent or adjoining property, or any construction activity for which a permit listed under subparagraph And there are a bunch of subparagraphs would otherwise be required. So as I understand it, the amendment is just to add the word underpinning.
Got it.
Or to have the sentence read the way I read it. And Madam General Counsel, you've got this,
Yes, yes, Mr. Chairman.
since I'm holding it in front of you. Is there, so I move the bill with this oral amendment. Is there discussion on the bill? And if there's no objection to the oral amendment, hearing none, is there discussion on the bill? Since the roll call vote on the declaration was unanimous, we'll do a voice vote on Bill 25-652 as amended. All those in favor say aye. Aye.
Aye.
Are there any no votes? I don't see or hear any no votes. The ayes have it unanimously. The next measure is PR 25-602, Housing and Downtown Tax Abatement Technical Amendment Emergency Declaration Resolution of 2024. Councilmember McDuffie.
Thank you, Mr. Chairman. Emergency and temporary legislation was introduced and is being moved at the request of the mayor. The council originally passed the Housing and Downtown Tax Abatement Program to incentivize offers of residential conversions in 2022 and made important substantive changes during last year's budget process. We've been expecting and implementing regulations for some time, and this emergency addresses technical administrative changes necessary before DMPIG can release the draft regulations for public comment. Regulations are conditional on approval of the proposed amendments to the program. And I understand that the regulations will be ready to release for public comment soon after the approval of this emergency. Briefly, the issues addressed in the emergency include clarifying that the Housing and Downtown program is a competitive one rather than a first come, first served program, specifying how the TOPA first sale exemptions is to be recorded, and adding flexibility of timing between the conditional approval of the tax abatement and the issuance of the final certificate of occupancy. With that, I move the measure.
We have the declaration before us. Thank you, Councilmember McDuffie. Is there discussion? We'll have a roll call vote on PR 25-602. Madam Secretary.
Councilmember Louis George. Yes. Councilmember Louis George votes yes. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Parker.
Yes.
Councilmember Parker votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trayon White.
Yes.
Councilmember Trayon White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Fruman.
Yes.
Councilmember Fruman votes yes. Councilmember Gray. Councilmember.
Yes.
Councilmember Gray votes yes, and Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Mr. Chairman, there are 13 yeses.
Thank you, Madam Secretary. The declaration is approved unanimously. The underlying bill is Bill 25-656. Councilmember McDuffie,
So move.
discussion.
Mr. Chairman.
Councilmember White.
Thank you, Chairman. I'm glad we're moving this. When the council approved the Housing and Downtown program last year, the expectation was that the program would commence no later than July of 2023. The program has been stalled for 8 months and the regulations are yet to be drafted. This delay is concerning. I think that we are not a few years behind, but at least 7 or 8 years behind developing housing downtown aggressively. Long before the pandemic started, there was significant office vacancy downtown, around 14%, which was much higher than a decade prior. At the same time, we have an immediate and significant need for housing. I've discussed this with Deputy Mayor for Planning and Economic Development. And my office spoke with DMPED yesterday and was promised that once this amendment passed, the program will be ready to accept applications by March. I plan to work with Councilmember McDuffie to ensure that this timeline is followed so that we can get this important effort underway. Thank you, Chairman.
Thank you. Councilmember, further discussion? The declaration was approved unanimously, so we'll do a voice vote on this bill. All those in favor say aye. Aye.
Aye.
Are there any opposed? I don't see or hear any no votes. The ayes have it unanimously. The next measure is PR 25-540, contract number DCRL 2022 B 0029 with District Services Management LLC, approval and payment authorization, emergency declaration resolution of 2023. Councilmember Louis George.
Thank you, Chairman. This contract is one of the examples where we are put in the position of deciding between sort of protecting the executive by fixing their mistake or not approving payments for vital services district residents rely on. In this case, transportation to school for kids in the care of CFSA. This contract was not submitted for the council approval until well after more than 1 million was expended and the contract term ended. Furthermore, the executive attempted to secure approval of a contract modification for current services in an amount less than $1 million. I decided to move this contract because I think we have to, given the position we're in and the potential harm to families who rely on this transportation. I'm also moving an amendment that removes the unnecessary and impermissible approval of the contract modification for current services less than 1 million. My office and the Office of the General Counsel have spoken with CFSA and the Office of the Attorney General, and the executive agencies do not object to this amendment. Transportation to school for youth in CFSA's care could not be more important, especially during the district's current truancy and absenteeism crisis, with children care having among the highest rates of absenteeism. While this contract should have come to the council earlier and in a proper form, it is necessary that the council act now to ensure these vital services are paid for. I moved the amendment to PR 25-540.
So we have the declaration resolution before us, correct? And then
Yes.
we have the amendment.
Yes.
Okay, so discussion on the amendment. Is there discussion on the amendment? I will ask you, council member, the amendment was cleared with general counsel?
Correct. Yes.
Yes, Councilmember Ryan.
I have a question to Councilmember Louis George. You're saying this is a transportation contract
Correct.
and transportation for our students?
Yeah, student in CFSA care. Yes.
All right, thank you.
Yeah, so the reason why it's under Councilmember Louis George's committee is because these are students who are under CFSA care. So they're students, but they're CFSA. Maybe I'll use the declaration to just say,
Yes, please read the declaration. I guess this, I'm glad you added where and you typed the students. It just seems that the larger our budgets get, that we're to pass judgment on, the more diverse the service delivery models are. And it just can boggle the mind of those of us, some of us who are sitting here, and I wonder how the public feels trying to draw a line from one agency to the other to track the service delivery models that we have.
Yeah.
And I just wish it was a little easier, but wishing won't get it. So I think we have to really pay closer attention to how we deliver services and how we can track them. And I'm using as a case in point, one of the services that is in my committee is found actually in risk management office. I mean, it's just, we're all over the place. And trying to do performance oversight and look at the schedule for performance oversight, we find ourselves frequently one committee bumped up against the other committee, same time, and it doesn't lend itself to, strong oversight. That's the concern that I have. Oversight that the public is paying attention to. Of course, we are talking to agencies and the service delivery system all the time, but when it is time to air for the public's comment, it makes it very, very difficult. And I think we ought to take a look at this more closely, Mr. Chairman. Just a recommendation.
Okay.
Observation.
My comment was a little different, and I'm going to use the declaration to talk about this rather than the underlying, because that's usually what we do. And that is that this contract, and this is, I'm critical, but not critical of the council member who's moving this. This contract was for this approval is for a contract that expired last September. I'll pause here. That's what, 3.5 months ago?
Yeah.
It was submitted to us, I think last week, again, for a contract that expired last September. I'm assuming that the committee is pressing CFSA why they couldn't get the contract over here more quickly. You will know that, you all will remember that we had something like this with DCPS last year. We had one contract in OSSI last year. I think we, as our committees with oversight, need to press these agencies on why they get these contracts to us so late. We have to approve it, as in, they just as soon get it to us on time. Rather than late, because it doesn't change the fact that it still requires council approval before there are payments. Is there anything, Councilmember Lewis George, you want to add with regard to CFSA's tardiness?
Yeah, we did. I did ask them why. They gave several reasons for the reason for delay. One, the contractor officer required the contract administrator to analyze the transportation referral and trip data and submit a report of the current and estimated future spending on the contract through September 30th, 23. Identify funding to support the additional service requests, council summer recess, legal sufficiency review and approvals from OCP, and then legal sufficiency review and approvals from the city administrator. So that was their reasoning for it, why there was a delay in submission provided by CFSA.
So in other words, the lack of prior planning. I'll just say that, just the lack of.
You
prior
said it, I
planning.
didn't say.
The lack of prior planning on the part of the agency. Forgive me, and this is a rhetorical question, but does anybody know when the council recess is this year? As in, didn't we know when the council recess was last year? As in, didn't the agency know when the council recess was? But that's, anyway, I don't want to belabor it. Any further discussion on the amendment? Let's do this. If there's no objection, the amendment will be accepted. Hearing no objection, it is accepted. We have the declaration as amended before us. Any further discussion? Hearing none, Madam Secretary, would you call the roll?
Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Parker.
Yes.
Councilmember Parker votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trayon White.
Yes.
Councilmember Trayon White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Freeman.
Yes.
Councilmember Freeman votes yes. Councilmember Gray.
Yes.
Councilmember Gray votes yes. Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Councilmember Lewis George.
Yes.
Councilmember Lewis George votes yes. Mr. Chairman, there are 13 yeses.
Thank you, Madam Secretary. The declaration is as amended is approved unanimously. We have the underlying bill, Bill 25-586. Councilmember Lewis George.
So moved.
Do you have an amendment?
Mr. Chairman, I move the amendment to be 25-0586.
And the amendment is the same purpose as the previous amendment.
Correct. Yes.
Discussion or questions from members about the amendment? If there's no objection, the amendment will be deemed accepted without objection. It's accepted. We have the bill as amended. Discussion. Since the declaration was unanimous, we'll do a voice vote on the bill 25-586 as amended. All those in favor say aye. Aye.
Aye.
I think I heard a lot of ayes. Are there any no votes? I don't hear or see any no votes. The bill is amended, is approved unanimously. We have temporary measures. Protecting consumer, and I'm going to move them in block unless there's objection. Protecting consumers from unjust debt collection practices. School Improvement Temporary Amendment Act, Medical Cannabis Program Enforcement Temporary Amendment. Protecting adjacent adjoining property owners from construction damage temporary, and Housing and Downtown Tax Abatement Technical Amendment temporary. I'm hearing no objection about moving the 5 measures in block. I don't believe there were any amendments. There was an oral amendment.
Yours or the protecting adjacent.
I'm the guilty one. Well, let's just say this. If there were amendments to the emergencies, the motion to approve the temporaries includes the amendments that were approved to the emergencies. And we know of one, which was the oral amendment on protecting consumers from unjust debt. I also want to note that school improvement temporary may be pulled off at second reading since the permanent is moving today, but we'll leave it on for the moment. So the temporaries conform in terms of amendments to the underlying emergencies. No objection to moving in block. I'll determine the secretary by asking her to do a roll call on this.
Chairman Mendelson.
Aye.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Parker.
Yes.
Councilmember Parker votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trahan White.
Yes.
Councilmember Trahan White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Freeman.
Yes.
Councilmember Freeman votes yes. Councilmember Gray.
Yes.
Councilmember Gray votes yes. Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Councilmember Lewis George.
Yes.
Councilmember Lewis George votes yes. And Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Mr. Chairman, there are 13 yeses.
Thank you, Madam Secretary. The 5 temporary measures are approved unanimously. Under other
Point of
business-
clarity, Chairman.
Yes, sir.
I see 3. You said 5.
Yes, on the next page.
Temporary request at the mayor.
So the 5 were the 3 at the bottom of page 7, protecting consumers, school improvement, medical cannabis, and the 2 at the request of the mayor on page 8, protecting adjacent adjoining property owners and housing and downtown tax abatement.
Thank you.
Those were the 5 that were approved first reading unanimously. Under other business, we have a motion to reconsider Bill 25-342 Public Charter School Board Term Clarification Amendment Act of 2023, now known as the Term Clarification Amendment Act of 2023. So moved. This was approved on final reading on December 19th, and I'm moving to reconsider it because there was a change in the amendment adopted at second reading that was incorrect, and it's going to be fixed by an amendment I'll move now if this is reconsidered. So I move to reconsider. Is there discussion? By a voice vote, all those in favor of reconsidering, say aye. Aye. Are there any no votes? The motion is approved unanimously. We have the bill before us. I'm going to move an amendment. The amendment is linked on the agenda. The amendment was circulated yesterday. The amendment cleans up the provision regarding the Office of School Time Grants and Youth Outcomes Commission. It has to do with the fact that there's a term limit. And the way the final reading, it didn't get it quite right. I'll read the rationale. Over the years, the council has struggled with the executive over partial terms for certain boards and commissions. The genesis of the underlying legislation was to clarify the issues of partial terms and term limits with respect to public charter school board appointments. Appointment provisions for some boards and commissions are unnecessarily convoluted and inconsistent from statute to statute, including appointments to the commission on out-of-school time. This amendment will clarify that a member of the commission on out-of-school time can be nominated for appointment by the mayor for up to 5 total full or partial terms. That's all this does. So if there's no objection, the amendment will be accepted. Hearing no objection, it's accepted. We have the bill before us as amended. Discussion.
Mr. Chairman,
Yes, Mr. Parker.
question. Can you elaborate on what prompted the change that is proposed by this legislation? I understood your explanation around the executive nominating and going beyond term limits, but was there an example of that happening with the charter board or one of these other entities that?
Yes, there was an
prompted this?
example with the charter board, and maybe 2 years ago, there was an instance before the committee of the whole with UDC Board of Trustees. So we've come up against this several times.
Got it.
I don't remember offhand others, but
Nothing pressing as in right now.
with regard to the commission on out of school time, nothing pressing, right? No, that's not correct. Yeah, I think there's somebody on OST who could be reappointed, but we're term limited.
Thank you.
So it's just, you know, as we create boards and commissions, every committee writes it a little bit differently. It would be great if we had standard language. So if we want term limits, then it would be written the same way. And if we don't want term limits, then that would be written a certain way. So when we have term limits, like I'll say the Public Charter School Board, which is 2 terms. Well, what if there's somebody on the board right now who was appointed to complete a term, and I think he served under that partial term for less than a year. And then he was reappointed. And if I remember correctly, the Public Charter School Board has a 2-term term limit. So that's like 1 year plus his 4 years. Is that all? That was the genesis of this legislation, was to fix that. If there's no further discussion, we have the bill as amended before us. Secretary said, sure. We'll have a roll call.
Councilmember Nadeau.
Yes.
Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Parker.
Yes.
Councilmember Parker votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trayon White.
Yes.
Councilmember Trayon White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Fruman.
Yes.
Councilmember Fruman votes yes. Councilmember Gray.
Yes.
Councilmember Gray votes yes. Councilmember Henderson. Councilmember Lewis George.
Yes.
Councilmember Lewis George votes yes. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes, and Councilmember Henderson. Councilmember Henderson is absent. Mr. Chairman, there are 12 yeses and 1 absent.
The bill as amended is approved unanimously. That's going to conclude the business of this meeting. There is a committee of the whole meeting scheduled for January 23rd. And with that, the time is 2:45 and this meeting is adjourned.